Thank you. Hi, everybody. Hi. I recognize some of you, but some of you seem to be new faces to these seminars. My name is Molly Foley-Healy. I'm an attorney who specializes in HOA law, and I don't know if that's a healthy thing or not, but I love it. And I have been coming up to ASPEN for at least 4 years now, doing educational classes for the Aspen-Pitkin County Housing Authority. I work with the city on HOA issues. And I just wanted to thank Afsha and Tom, and Cindy in the back, and Pam, and all the folks who are on the Aspen board, Ron and Marcia, for doing these. These have been great fun, these classes. And this class is a little bit different. Normally what I do is legislative updates, but the session's not over yet, so we don't know for sure what that will be. And then we've gone through some real legal classes. Well, I'm going to talk definitely about legal concepts in this class. What I really want to focus on is what it takes for both the homeowners and boards to make a good, functional living community association, an HOA. How many of you are on boards of directors of your HOA? Okay, how's the pay? Is it pretty good? Okay. How many of you are homeowners? All of you that are on boards. Okay. How many of you, this is the first time you've ever lived in an HOA? Oh, wow. Big difference, isn't it? All of a sudden I have use restrictions and all the other things that go along with homeowners associations. How many of you have a good experience in your HOA? You think it's a good thing? Okay. Are there any unhappy people here with their HOAs? Okay, so maybe we can talk about how to make that a better thing for you, how to make your experience in living in an HOA better. How many of you lived in condominium associations, condos? I do a lot of work up in this area, and most of my clients, actually all of them, are condominium associations, which is pretty typical. Single-family home communities? Okay, condos and single-family home communities will have sometimes different issues just because of the proximity you're living in, and you have adjoining walls or you don't. So what I want to start with is, what is a homeowners association? Does anyone want to give me a run at it? What makes something a homeowners association, an HOA? Okay, the bottom line with an HOA, and I'm not going to read you a boring statute, I'm going to just explain it, is a declaration of covenants, conditions, and restrictions is recorded, and it takes the property, which is the underlying real estate of your homeowners association, and it subjects it to that declaration. So normally you'll see in declarations, you'll see the following property, which is usually in Exhibit A of your declaration, is subject to the declaration, meaning anybody who owns or purchases or owns a unit in a condominium association or a lot in a homeowners association, a single unit plan community, is subject to that declaration. And so because it's recorded, you have record notice of it, and that means you have a contractual obligation to comply with the provisions of the declaration. A lot of people don't know that. A lot of people, you know, they get their declaration prior to purchasing their unit, and it goes in the pile of documents that you closed with, and it's never pulled out again. Unfortunately, from time to time I hear about boards that have never pulled out the declaration for their community, and it's impossible to govern your community unless you know what's in the declaration. So for a planned community, a single-family community, it's typically called the Declaration of Covenants, Conditions, and Restrictions. Some of the older documents will call them protective covenants or use restrictions. For a condominium, it's usually going to be called your condominium declaration for whatever community you live in. Okay? So what are some common names for HOAs? You'll hear these all the time. Community associations, that's a general name that we use across the country to describe HOAs. You live in a community, you have common areas, you live in almost a cooperative manner, because you have to get along, you have to pay assessments, you have to function hopefully in a positive way with one another. Planned communities in Colorado, that's a term in our statute. So we have something called the Colorado Common Interest Ownership Act. You'll hear me refer to it as Kiowa, CCIOA. It's not the town in Colorado. And that is a statute that regulates all HOAs in Colorado, okay? At least most all HOAs in Colorado. And they have a term in there called planned communities. And planned communities are simply single-family home communities. They're not condos. It's everything but a condo, okay? Condominiums are a type of HOA. Townhomes are a type of homeowners association. And then I work with a lot of mixed-use communities where we have both residential component of the HOA, and we might have a commercial component. So you might have a condominium association where there's commercial on the ground floor level, and then the residential units are on, you know, the floors above it. So you can have mixed associations. All right, so what do you need to know as the foundation if you're moving into an association, if you live in an association, and if you govern the association as a member of the board? It's essential to understand that you have to, homeowners, and that includes board members, by the way, have to comply with the governing documents of the association, and boards of directors have a fiduciary duty to enforce and comply with the provisions in the governing documents. The first one at the very top is the most important governing document of association. It's the declaration. So remember, condominium declaration for condos, declaration of covenants, conditions, and restrictions for planned communities, single-family home communities. That document is in the hierarchy of documents. If you have documents that are inconsistent, your declaration is always going to be the document that is going to control. So things to look at in your declaration. Use restrictions. You know, can you have pets? Can you have rentals in the condominium association? All of those types of things, what you can and cannot do in your units. Is marijuana prohibited in your condominium or in your homeowners association? Those are going to be in your use restrictions. The two big areas, particularly in condos, that are really important to look at is the maintenance article of your declaration that talks about what is the association responsible for maintaining, and then what are the owners responsible for maintaining. Is the association responsible for maintaining any part of the unit, your condominium unit? You need to take a look at that, and you need to take a look at what the association is responsible for maintaining. Similar to that, and this is so essential, everybody, and whenever you go to get your insurance renewed for your home or your condominium unit, take your declaration with you to your broker and hand it to them and say, I need to make sure I have enough insurance. In condominiums typically are going to insure part of your unit, and it depends what your declaration says. You might have full insurance that covers betterments and improvements, so that means that if you put in granite countertops and cherry cabinets, that if there's a loss to the unit, the insurance that the association carries for all of the units will cover it. Some have bare walls coverage, which means that the association's insurance is only going to cover drywall and tape. Okay, they're not going to do any betterments or improvements to that unit. So you as homeowners want to know, what is the association going to cover for my unit? In single-family homes, associations will never insure your single-family homes. That's all the homeowner's responsibility. But if you're in a condominium, and the vast majority of you live in condos, you want to make sure that you're carrying insurance that covers everything the association isn't. I get into nightmares with clients when, let's say, the association is required to carry bare walls. So if we have a major water leak event and there's major problems with, you know, just destruction from water from a unit above it to the unit below it, the association's insurance is only going to cover sheetrock and tape. If you have a bare walls coverage and you as the homeowner aren't carrying an HO6 policy, that's the name of the homeowner policy that covers all the betterments and improvements to your units, everything but the drywall and tape, you're going to have to pay for that on your own, and that is a nightmare. And sometimes people don't understand they're not carrying adequate insurance. You're also going to look at what are the common expenses of the association. What do your assessments pay for? Okay? And here's the big thing, guys. One of the big issues that we get into in the homeowners association world is what happens when somebody's delinquent in their assessments. A lot of that's going to be covered in the declaration. It's also going to be covered under Colorado law. So your declaration is really the roadmap for your rights and responsibilities in the communities, both as homeowners and board of directors. Okay? So if you don't have a copy, get a copy. Because you can't really function you cannot govern an association as a board unless you have that declaration with you at every meeting. Yes?
You said the declarations are that they control all the documents. If you have a 40-year-old declaration and now Kiowa comes and has new laws, does Kiowa supersede?
Okay, so the question is, if you have an old an old declaration, whether you're a planned community or condo, does Kiowa supersede it? In many cases, it will. So. One of the big things that we see legislatively is HOAs are always hot legislatively, so they're always making changes to the law in Colorado. If the law applies to what we call pre-Kiowa communities and Kiowa communities. So Kiowa was signed into law and became effective on July 1st, 1992. If your declaration for your community was originally recorded on or after July 1st, 1992, you are called a Kiowa community. That means all of the provisions of Kiowa apply to you. If you're an older association where your declaration was originally recorded prior to July 1st of 1992, only some of the provisions of Kiowa apply to your community. And those are normally what I call the Homeowner Bill of Rights provisions. Open meetings, secret balloting at elections, when you can go into executive session, association records, all of those apply to both pre-Kiowa and Kiowa communities. When there is a change in the law in Kiowa, you do not have to go and amend your declaration. How many of you have amended your declarations? Okay, it's a process, right? I mean, you've got to get a lawyer in there to help you with it. You have to go through a voting or a consent process. It's a process. So if Kiowa is different than what your declaration says and it applies to your community or either pre-Kiowa, it will always apply to our Kiowa communities, then Kiowa will automatically trump it. And so you don't have to go in and amend your deck just because there was a change in the law. But if you've got, 40, I have some documents from the 1960s with clients up here. If they're that old, at some point, you might want to consider modernizing your documents, bringing them into compliance with the law and making them understandable. All right, the next thing is the Articles of Incorporation. So most homeowners associations in Colorado are nonprofit corporations, and you're incorporated with the Secretary of State of Colorado. The Articles of Incorporation will normally say, here is the entity, the declarant, the developer who created the association. Here's the initial board of directors. Here's the basic powers of the board of directors. It's not that often we really use the Articles of Incorporation unless we're really into a question of, does the board have the power or authority to do something? Okay? And so that can be found in three places. I put it in my declarations. It also can be found in the bylaws and the Articles of Incorporation. So usually Articles of Incorporation are not a document that we need to go to unless we have those types of issues. The bylaws. This is a very important document because it addresses the governance of the association. And this is important. How are boards elected? What are the qualifications of directors? When do we have annual meetings? How do you get to vote? All of those things in terms of how your association is governed by the board of directors and your rights to vote on issues as owners in your association, as members, are governed by your bylaws. So you need those for annual meetings. The board needs those to make sure they're functioning according to the bylaws. Rules and regulations. That is a document where, under the authority of Colorado law and typically the declaration, the board has the power to adopt certain rules and regulations. And those rules and regulations usually fall into three categories. One is if the declaration is unclear on a certain use restriction, a lot of times the board can adopt a rule and regulation to clarify it. So if we have a pet issue, we can clarify unclear provisions in the declaration. Also, generally speaking, boards have the ability to adopt rules and regulations which affect the use of the common areas, the common elements of the association, and only relative to units when the conduct that people carry out in their own homes, in their own units, affect other unit owners, affect other homeowners, or affect the common elements. So you're doing something in the unit that could, be so noisy, for instance, that the people around you can't enjoy peaceful and useful enjoyment of their unit. You're disrupting the entire association. Or you're doing something where water could come out of your unit and affect other units or the common elements. Policies and procedures. How many of you, a lot of my APSHA communities here, how many of you have heard of the SB 100 policies, responsible governance policies? Okay, there are 9 policies required by Kiowa that all community associations have to have, and they deal with things like collection of delinquent assessments, conduct of meetings policies, alternative dispute resolution policies, records inspection policies. There's actually 9 of those, and those are policies that are actually required by statute. So all of these different documents make up the governing documents of your association that you need to be aware of, because that is what governs the authority of the board, the responsibilities of the board, and then you as homeowners, you need to know what do those documents say so you're not inadvertently violating something. All right, so how are HOAs governed? So how many of you have been serving on the board again? A lot of you. Is it a good experience? Do you feel loved by the homeowners of your association? Okay. All right, so how are associations governed? It's really a democratic elective form of governance. So the members of the association, the owners of units in the association, elect a board of directors to administer, operate, and govern the association. Okay, and they're elected by the members at annual meetings generally for vacant positions on the board. Generally speaking also, if somebody is on the board of directors and resigns their position, depending on what your bylaws say, the remaining directors typically have the authority to appoint a member of the association to either serve out the remaining term of the director who resigned or to serve out the term until the next annual meeting where the members will do it at an election. And so that's going to be based on specifically what your bylaws say. Qualifications of directors is something I've been running into a lot with my clients. A lot of times they will say that you have to be the fee simple owner of a unit in order to be qualified to run for the board of directors. You have to be an owner of your unit, of your home. And sometimes for estate planning purposes or for whatever reason, with married couples, sometimes only one person will be on title to the unit. So the question is their spouse able to run on the board of directors? And you have to look at the bylaws to determine what are the qualifications of directors. I've been doing amendments for a lot of my clients that say spouses, individuals in a civil union, are permitted to run for the board of directors even though they are not on title. And that's absolutely up to the discretion of the association whether they want to broaden that out or not. So I've been dealing with that a lot. The numbers of directors, the number of members of the board of directors are also typically going to be found in your bylaws. I usually have, when I'm drafting documents for my clients, I usually have a corresponding provision in the declaration that also generally covers that. But your bylaws are going to regulate the number of directors, generally speaking. So go out and dust those puppies off and take a look at them. And I won't ask for a show of hands for how many of you take your governing documents to the board meetings. All right. This is really general, you guys. I could talk about fiduciary duty for an hour and a half, and you would be nodding off and drooling, and that's not a good thing. So what is the fiduciary duty of directors to the association? So once you're elected to the board of directors, what is your general duty when you're making decisions and governing your association? First of all, you have a duty to act in good faith. And that means you're not acting out of your own personal agenda. And so the bottom line is, for many, many people who run for the board of directors, many people run because something just irritates the heck out of them in the association. Anybody? I mean, I think a lot of my boards have, I'm irritated about parking, I'm gonna run for the board and I'm gonna fix this. So when you act in good faith, you have to set aside your own ego, your own personal agenda, and act for the association and be clear about what your motives are. You have the duty to act in the best interests of the association. And from a legal perspective, that can mean the corporate entity, you know, the legal association, the nonprofit corporation. But in the real world, what that means ultimately is you have to act in the best interest of the members as a whole, as opposed to your neighbor who you really like, or somebody down the street that you really don't like. You're not going to make a decision that, you know, inappropriately affects them. So you're acting in the best interest of the association as a whole. When I think of especially some ASPEN clients, some APSHA associations, we're thinking about things like creating a budget where you have your operating expenses are enough, adequately reserving for future major repairs and replacements which the association is responsible for. You're looking at acting, using your business judgment to act in the best interest of the association as a whole. And then this is the last one that throws some people. The duty to act with loyalty for the association. So I always tell my clients, without being rude to one another, in board meetings, passionately debate issues. Feel free to disagree with each other. It's okay. Because the whole part of coming to decisions is feeling that you can just voice your opinion. Now, that does not mean personally attacking other people that don't agree with you, being rude, screaming and yelling. I've been to those meetings, and that's dysfunctional and it's no fun. So being able to freely share your opinions, but here's the kicker. Once the board makes a final decision on an issue, you vote to take action in whatever particular way. Just because you didn't agree with the majority of the board, you can't go out in the community and try to diss the board, try to get it unraveled, try to undo what the board did. You have a duty to act with loyalty on that. What does that mean? It doesn't mean that you grab your pom-poms and go out and cheerlead for a decision that you don't like. Okay? But I have told directors on my boards that, you know what, if you're going to go out and undermine an ultimate decision of the board, which was not an easy decision, that's okay, but resign from the board and do it as a member of the association. Okay? Because it's not good when board members are out trying to nuke, you know, hard decisions that the board came to. All right, hot button issues in HOAs. The first one would be failing to adequately reserve. This is really essential in condominium associations. So reserves. Reserves are funds that you set aside to provide for major repairs and replacements of those things the association's responsible for. Okay, so it could be things like roofs of a condominium association, siding. It could be asphalt. All the major projects in parts of the association that the association is responsible for maintaining, repairing, and replacing. So we're not talking about general maintenance. We're talking about major repairs and replacements. What happens when you don't have reserves? Have any of you experienced that? That's when I don't want to go to your annual meeting. Because when you fail to adequately reserve and you've got leaking roofs, you've got deteriorating siding where water's intruding and you have mold, and the infrastructure of your community is breaking down, you're going to have to do a special assessment to get the money to do it. Or you're going to have to try to get a loan from a bank to do it. And that's not absolutely a bad option. I think that can be a good option. But the fact that you didn't plan for it because we didn't want to raise assessments, I mean, let's face it, it is no fun raising assessments, and it's much worse to have a special assessment. Where people really get revved up and get their knickers in a twist, so to speak, is when we're affecting their pocketbook, right? That's when people wake up and take notice. And I have found that it is much more wise for clients to slowly do assessment increases so we're regularly, on a yearly basis, contributing to our reserve account than to just put our head in the sand and have no money and then be stuck. Have any of you experienced that in your communities where you've got, yeah. Is it ugly? Did you have to do a special assessment? How did that go with the owners? Yeah, and you can't collect it. It is very stressful, especially if people are living from paycheck to paycheck on a tighter budget. They haven't planned for a special assessment. I have a client that had an EFS problem, so that's kind of this, do we have any engineers here? It's kind of a stucco outside exterior of a building. And these EFS systems were really popular, and they frankly leak like sieves if they're not done appropriately. And the association had been reserving, but it's a 74-unit condominium association. They had a $1.3 million special assessment. Some units are paying 50 grand. I don't know about you, I don't have 50 grand hanging out for a special assessment, and if I did, I'd be pretty ticked because I probably have an earmark for something else. But that can be incredibly stressful. So part of your duty to the association is to look at the finances of the association to make sure you're adequately planning not only for your current operational year so that you're adequately budgeting for your normal operating expenses, but you're also looking to the future so you've got money in reserves when you need it. So we just kind of hit normal budget too. The other thing is associations, I think, can get into trouble when you're not being realistic about really what your normal yearly operating expenses are because you don't want to do that assessment increase. So even for those associations that are reserving, if they're not budgeting adequately for their normal operating expenses, they're robbing Peter to pay Paul. They're dipping into those reserves that are intended for those major repairs and replacements to cover your normal operating expenses. So really look at those things. Okay, so maintenance and repair issues. As I said, look at your declaration because your declaration is going to tell you who's responsible for maintaining and repairing not only your unit, but the common elements or limited common elements. Limited common elements in a association can be things like balconies, decks, things that are common elements, but they're pertinent or really only for your unit or for a couple units. Who's responsible for keeping those clean? Usually the owners, but the declarations differ on who's responsible for maintaining, repairing, and replacing the deck, the railing, those types of things. Look at that so you know what it is. The next one is pets. And so my paralegal's great with, PowerPoints. And so I said, yeah, throw a dog in there. She went on my Facebook page. These are my children. The Labrador Retriever is Maggie, and the two beagles are Lily and Finnegan. Finnegan's the little fellow in the back with his chin on Maggie's back. That's their bunch, and they hang out like that together all the time. But in Aspen particularly, you have a lot of associations where dogs are prohibited. Right? Any issues there? All right, so If dogs are prohibited in the declaration, you cannot permit them. Okay, so let me be clear about something. So sometimes with rules and regulations, boards will try to trump the deck by saying, well, we'll just adopt a rule that says, yeah, you can have them. Okay, you can never adopt a rule that trumps the declaration. Your declaration is always the document that's going to control. However, while I said you can never permit them, there is something called an assistance animal under the state and federal Fair Housing Acts. And many assistance animals are absolutely legitimate. It's also my belief that many assistance animals have become the loophole for ASPEN for people to get dogs. So this applies for federal and state Fair Housing Act. So if somebody has a disability where they feel that they need an assistance animal in order to use and enjoy their unit, to live in the community, to use and enjoy the common elements, the association is required, it's called, to make an accommodation to the rules to permit them to have an assistance animal. Here's a few tips, guys. If the disability is visible and apparent, or if you know about it, so you have somebody who's blind, you have somebody who everyone knows has depression, if you either can see the disability, it's apparent, or you know of it, you cannot ask the owner who wants the assistant animal for documentation to prove they need the assistance animal, okay? You will end up in the Colorado Civil Rights Division. I hate working there, dealing with these issues. I deal with handicap parking there all the time too. But you will end up with a violation. However, if the disability is not apparent and somebody requests an assistance animal, you can ask for documentation from a doctor, a nurse, a physician's assistant. If it's psychological in nature, if somebody's claiming anxiety or depression or something like that, from a therapist, a social worker, anyone that would have the ability to determine whether there's a disability and whether an assistance animal would aid that person, then you can request that documentation. Okay? But here's the kicker. If you either know they have it or they provided documentation, you can't prohibit it. You have to accommodate it in the rules. You have to say, okay, you can have it. Now that doesn't mean it's a free-for-all, right? That doesn't mean that their dogs can run around the community without a leash. It doesn't mean that they can never pick up poop. You can't require poop pickup. That's my technical term. It's poop season, by the way. It's spring when you see it all. You know, you can require them to be responsible pet owners. All right, so I'm actually working with some of my ASPEN clients right now on policies to deal with this because it's become such a big issue up here. And I think it's because, it's my understanding that because of, you know, animals and working ranches and that kind of thing, that over the years, that's why they've, in many cases, restricted or prohibited dogs. So, yes?
I live in an 8-unit. 2 of the units, the 2 largest ones, pets are permitted. Yesterday I get an email. They want to put pets in all of them, and there's some really little big baby ones. If it came to a vote, would all owners have to approve yes to the pet?
Okay, so she said, and she lives in an 8-unit condominium association. 2 units currently have pets. Does the declaration prohibit pets?
Except in the 2 large units.
Oh, that's ridiculous. What lawyer wrote that? I'm sorry if you're here. You know, if the declaration prohibits animals except for in 2 units, that is ridiculous. But what I would do is I would amend the declaration to just prohibit dogs or cats or whatever, pets, whatever it is, to make it clear that you can do it.
The 1 unit has pets, and I do not, yeah, of the permitted units.
That is wild. That's a new one for me.
So what's the requirement on, does everybody have to vote for it, or is it 75?
To amend the declaration, good question. So what do you do to amend the declaration? So if you've got really old documents, like 40 years, 30 years. A lot of times they will say 100% of the owners must consent. Kiowa, and this applies to pre-Kiowa communities, those communities before that were created before July 1st of 1992, defaults the percentage that have to consent to an amendment down to 67% of the owners. So if you've got 100 owner consent or 75 or 90 or 80, you default it down to 67% by statute. That's where the good question that you asked about, does Kiowa trump a declaration? Yes, it does in cases like that. All right. So covenants and rules enforcement, has that been an issue? What kind of rules have you had?
Calling a meeting, or we're supposed to have one of our general common areas is supposed to be clear and not offensive to anything. And some people on that side really wanted to put up gates to keep other people out. I'm like, oh, no, it says you can't obstruct or whatever. And then they were like, well, we don't think that it's a hindrance, you know.
Just an owner saying that?
No. Like they got little kids, so they wanted to abide and but that's the only way I get around my house. So I'm the only one negatively affected by it. So they just wanted to, I don't know, but I can't even call a meeting with them now because they're annoyed with me. So 3 out of 4 of us are starting to restrict rights and take away rights and just ignore me.
Okay, so that's where, that's one of those issues. That's not necessarily a use restriction that I was thinking of, but that's what can you do to the common areas of the association without getting approval? Okay, can you obstruct the common areas? Can people build stuff into the common areas? I found that up in this area, not knowing that the hot tub I'm putting in my backyard really is in the common elements, and it's really not your area to put it in. Things like that. That's an issue where the board needs to get in with legal counsel right away to take a look at how to deal with that, because if you're building things into the common elements, there's a statute of limitation on improvements that could kick in. Now, I would argue it's a trespass because, especially in a condominium association, you don't own all the common elements, so you don't have a right to build into them, but you may have to take some formal action against them to deal with those situations. What I'm talking about with rules and covenant enforcement mostly are those use restrictions, pets, pulling out your garbage can. What are you thinking of, Ron?
We have is providing keys to manage.
Oh yeah, providing keys. In condominium associations, many times the declaration will say you have to provide a key to management because if they need emergency access to do, let's say we have a water leak and we're trying to figure out where the water leak's coming from, and any of you who have lived in a condo know that water goes out and down, right? And so if you need to get into that unit to either stop a leak or investigate something, if you don't have a key, then you can get into issues of how do you deal with it. That's a problem. I mean, the declaration needs to, generally speaking, I want the deck to specifically give the association the authority to have that key. And then what I will draft into my documents is, if you don't do it and you're only using it for those types of emergency access or other things the association has the responsibility to do under the declaration, if it's an emergency, we're going to break down the door. If it's a non-emergency and you just never gave the key, we're going to have a locksmith come in and rekey it and gain entry that way. So those are issues. So covenant enforcement, dealing with people, communicating with people. A lot of times I find homeowners won't comply with use restrictions or requirements in the declaration or rules and regulations because they don't know about them. So I always like to start with, do they know about them? Are we communicating what those things are? And then, communicating them. Then you all are required under Colorado law to have what is called an enforcement policy. It's one of those 9 SB 100 policies I told you about. And before you can levy a fine against a unit owner for failing to comply with the documents, you have to give them notice that they have not complied and an opportunity for a hearing prior to levying an assessment. A lot of communities don't know that, and they're levying fines, not levy assessments, levy a fine against someone. Yes, Marcia?
Question. Your 9 rules of governance are in conflict with your conduct acts and bylaws, which take
the deck. And that's what happens when you go get a template or you borrow somebody else's rules and regulations and you put a new name of an association. What we as legal counsel will do is we will look at the declaration particularly to make sure that when we're drafting that policy, we're not inconsistent with the provisions of the deck. But if the declaration is trumped by Colorado law, then there's all sorts of issues that go along with that. But generally speaking, your declaration is always going to trump your policies, your rules, and regulations. Okay? Okay, so this is like one of my favorite things. If you go on the back page is a link to our website. We don't track this. I blog a lot. Right now it's boring, it's legislative stuff. But I blog a lot on what boards need to know and what boards need to do because, you know, a lot of boards just have the best of intention, but they don't know some laws are hanging out there. And so I do a lot of blog entries, and I did this series about 3 or 4 years, well, no, a couple years ago, on traits of highly effective directors of HOAs boards. And I really, this comes from a lot of experience of, I've been working in the HOA world for years, of what I have seen in terms of trends and, you know, things to look at and think about. So a highly effective director understands it's all about the HOA and not about their personal agendas or egos. There are occasionally, and I don't find this to be the majority by a long shot, but occasionally you'll get somebody on a board, man, they have no listening skills, but they're going to tell you what they think. And it's all about their ego. And if you don't side with them, it's a nightmare. And remember what I said in terms of fiduciary duty? Directors have the duty to act in the best interest of the association. And so as directors of homeowners associations, we always need to take our ego, park it at the door when we walk in the boardroom, because that can be a problem. This is another big problem. Never act as the Lone Ranger. I love the little horse picture there. No director, unless it's specified in the bylaws, you have express authority in the bylaws, or the board passes a resolution giving an individual director any particular authority, no director, generally even including the board president, has the authority to act unilaterally on behalf of the entire board of directors. And sometimes you'll get that board member who's out there, they're the Lone Ranger, man, right? They're making decisions, they're signing contracts, it's never come before the board. Generally, so look at your bylaws. On the officers, there's usually an article on officers. Look at what is the authority of the different officers on the board of directors. So unless the bylaws specify authority, or unless the board has passed a resolution giving that director specific authority, one person, you can't act as the Lone Ranger. And that's why I don't want, for my clients, I don't want one director emailing back and forth with owners about a decision that the association has to make or an issue. Because sometimes with the best of intentions, a director will say, well, the association is going to do X, right? And then the board talks about it and meets and does Y. And the association member, the homeowner, has relied upon what that director said in email. I see this with like architectural improvements. Oh, go ahead and, you know, build that on a common elements. It's not a problem. And it is, and the owner did it, and then what happens? You know, the owner relied upon a director. So they argue equitably, you can't come against me, I relied on you. Passionately debate issues and support ultimate decisions. What I talked about in that you have a duty of loyalty to the association. Please, by all means, respectfully disagree with one another in the boardroom, but then make a decision. Also, get off governing via email. I'm serious. If I could take away computers from every one of my directors, I would. Because it's human nature, right? I'm guilty, you guys. We will say things in email we would never say in an open board meeting. And those happen to be records of the associations. So if you say something negative in an email where you're making a decision or debating an issue, homeowners have a right to request those emails and the records of the association. The other thing is, if the association board is sued, we have had situations where judges have required the seizing of personal computers and going through personal emails to find evidence specific to a case. And first of all, there could be stuff about association business you don't want seen, right? Because it's not going to look good. It's going to look like you're prejudiced against someone, or you had a personal agenda, possibly. But more than that, I mean, we all have personal stuff in our email accounts, right? That we just don't want the world to see, and so we don't want a judge going through that. So I recommend only use email communications when it's absolutely necessary. If there's an emergency, if you're scheduling a meeting or something like that. But don't routinely discuss issues via email, which you should be talking about in an open meeting at a board meeting, okay? That's the same thing as committing to governing with transparency. So when boards tend to make decisions outside of meetings, which is permissible under law as long as you're following the requirements of your bylaws, what happens is, especially if it's significant, if it could lead to an assessment increase or possibly a special assessment, people are going to think you're hiding something even when you're acting with the best of intentions. Okay, so your emails could be pure, they could be constructive, but if you're not talking about tough, important decisions that need to be made in a board meeting that members have the right to be at to listen to the discussions, it is human nature to think they're up to something. What's really going on there? And so you don't want that to happen. And that's why under Colorado law, by the way, board meetings must be open to all members unless you have a legal reason to go into an executive session. Okay? Uh-huh.
If your board is
In the declaration from the bylaws, they're the ones that set your assessment.
Mm-hmm.
Do the homeowners have a right to be there to listen to that conversation of how to determine your assessment amount?
Yes. Okay, so the question is, if the board has the right to set the assessments, do the homeowners have a right to be at the meeting to listen to how the board gets there? And that's that whole transparency issue. And a lot of times, even though you might have an assessment increase, it's because basically costs have gone up, right? So it's legitimate, but if homeowners don't know that, they can, assume that you're doing nefarious things. Has anyone experienced that? The people who are the conspiracy theorists in your associations? And it doesn't matter what you say, there's a conspiracy. So on budgets, I wanted to talk about a couple of things. First of all, look at your declaration and bylaws to see how budgets are handled. Pre-Kiowa communities are generally, many of them are not going to have a homeowner approval or a budget ratification process. If you've got an older community, it's likely that the board can adopt a budget and set the assessments without homeowner approval, okay? In newer communities, it typically is going to have a budget ratification provision, which is consistent with the direction of Kiowa, and that says the board adopts a budget. They send the proposed budget out to all of the owners. They set a membership meeting, and then unless 51%, sometimes it's 67, sometimes it's higher, unless a percentage of all members veto it, the budget's automatically deemed approved. So look at what your budget provisions are, and that's going to be in your declaration, okay? All right, other effective directors. Oh, this is a biggie. They disclose and effectively deal with conflicts of interest. So let's say I'm on the board and my husband has a landscaping business. And we make money from his landscaping business. And I want my husband's landscaping business to be considered to handle the landscaping for the association. Good, effective director, if I were appropriately acting, I would disclose that I want my husband's business to be considered as one of the contractors. I would disclose that in an open board meeting. I would recuse myself from discussing and voting on the issue. So you're open with conflicts of interest. One of your 9 responsible governance policies, your SB 100 policies, is your conflict of interest policy. Yes?
Now, conflict of interest doesn't only have to be a financial interest, does it?
Well, the question is, does a conflict of interest only have to be a financial conflict? Depends what your conflict of interest policy says. The Colorado Revised Nonprofit Act basically defines a conflicting interest transaction as having financial implications. I like to draft into my policies that if a board member is affected in a way that's different than all of the other members in the association, it's potential conflict of interest. So let's say we have a barking dog next door, and I'm on the board, and I have complained about it, because I'm really the only one affected by it, but I'm irritated. It's a beagle, okay? And beagles are annoying when they bark, particularly Finnegan. So anyhow, and I'm just annoyed as hell with this. I can't stand it. The people leave the dogs outside for 50 minutes at a time barking, and I make a covenant violation. Do you think I have a potential conflict of interest to sit on the committee that decides whether there's a violation? I think so. And so a lot of times I will draft into my conflict policies, or at least in the enforcement policy, that if I have a interest that's different than all the other homeowners, I have a conflict. So I'm not going to sit on the covenant enforcement hearing committee to determine whether that beagle needs to quit barking. You know what, guys? This last one is so non-legal, but I think it's the most important of what makes a great director. They are phenomenal listeners. They listen to people. And I think this is true for managers too. So community association managers and boards of directors, if you don't listen to what members have to say, it doesn't mean you have to decide with what they tell you to do, but if you don't really listen to them, they are not going to respect you, and you're going to have all sorts of interpersonal problems in the community. Really good directors and really good managers listen, and they actively listen. They don't, you're sitting there going through your board paperwork, somebody's talking, you're not focusing on them, you're not listening, and you're not being respectful. You're going to have problems in your community. Or you fight with them. That's not good either. So I just think really highly effective directors are phenomenal listeners. All right, by the way, I happen to live in an HOA and I love it. Nobody knows what I do, by the way. I live in an 800-unit community association in Arvada, and my husband manages a big high-rise condominium. I practice HOA law. Nobody knows. Okay, so happy and effective HOA residents. So if you want to be happy in an HOA, here's, I think, tips. One is, you are familiar with and comply with those governing documents. All right? When the garbage can be out in the drive, right? That pets can't be off leashes. And you've got to pick up poop. So those basic things. Parking, pool, and pets. We don't have a lot of pools up here, but parking and pets, I think, we call them the 3 Ps, but parking and pets are 2 of the most significant issues. All right, so and this also goes to board members, guys. They get informed before they react. They find out really what is the foundation of the issue. I mean, you get these homeowners that come to board meetings and then board members that react, and it's horrible. They don't know, they don't go to board meetings. Let's say they didn't even go to a board meeting. They're just pot stirring around the community. They haven't gone to board meetings. They haven't gone to the annual meeting. They haven't read the governing documents, but they've got a bee in their bonnet, and they are just out pot stirring. So a good homeowner is informed before they go off on a tangent and get crazy. They understand that money doesn't grow on trees. I'm serious. What annoys the heck out of me, and I'm sure annoys boards, is these people never want an assessment increase, but they want all the bells and whistles in the community, right? And so they're ticked off because we don't have X, but this community next door to us does. But they will, go after you if there's an assessment increase on the table at an annual meeting. I mean, really, generally speaking, the only income in a homeowners association is the dues that members pay. Occasionally, if you're a condo, maybe a high-rise condo, or if you've got extra property, you might have antenna contracts where an Comcast or something like that will pay you to rent property to put an antenna or something. But generally speaking, the only way that HOAs get money is by the dues that the members pay. They communicate if they have problems or issues. And so here's the thing. A lot of times people have issues. Let's say we have a catastrophic illness, we have a loss of a job, or something significantly has happened in the family, and you're having financial problems and you can't pay your assessments. And you need a payment plan, you need the association to work with them. Instead of not dealing with it, instead of not facing it, they won't say anything. A really effective homeowner will quietly talk to the board, and boards will always talk with them privately about that, or a manager. And if you communicate you're having problems, if you communicate something's going on confidentially, that is such a good thing. Because you don't want, a major lawsuit for delinquent assessments when there's something that the association, I have never had a client when something major happens in someone's life that they won't work with them. I have found, frankly, that most of my boards are such good-hearted people because we've all been there at one time in our life. So communicate. They are part of the solution, these really effective homeowners. You know what's annoying? I'm probably preaching the choir here. I'm just going to be blunt. The bitchers that come to meetings and complain. All they do is complain. Do they ever offer a solution? Do they? Have you ever had those people? I mean, it's constant. And no matter what you do, you will never make them happy. But you know what? Boards appreciate if somebody comes and says, hey, there's an issue, and I just want to throw out an option for fixing it. Here's an option to consider. So bringing those solutions. They participate in their community. They go to annual meetings. They get informed. If you have a picnic in the summer, they go to the picnic. They run for the board. They serve on committees. These are really great people. And I think this is key. They treat their neighbors and the directors with respect. And I want to say directors need to treat homeowners with respect. I want to shake directors that get in people's face. I mean, it's a community. It's a community association. It's so essential to treat each other with respect. And that's why, as an ending point before I take questions, in my opinion, healthy, functional, dynamic homeowners associations, it's really all about mutual respect for one another. The manager, the directors, the homeowners, they mutually respect each other and they communicate with each other. And I'm not talking about yelling and screaming. They treat each other respectfully when they communicate. So, are there any questions? I can't imagine you could possibly be here at an HOA seminar without questions. By the way, they are going to be bringing a microphone around so that it's taped, and when you can ask your question. This gentleman right here.
Hello.
Hi.
Can you hear me?
I can't hear. I think it needs to be. Is it on? Are you picking up? You're fine. Okay. He can hear.
So this is almost like living in a community with people. It incorporates therapy, but you have legal obligations. So you have your declarations.
Yeah.
So you'll have people who read them and know them, and then other people who that's not their strengths in life. So you have professionals who know this, and you're working with other people. So all who and sometimes come from a point of view of I want or I need. and they can't read the paper. So you can comment on this, but your two things here is mutual respect, communication, and listening. So that's really important for the people that are at a disadvantage that don't understand that.
Right.
To work with them,
Right.
explain, and
Yeah. And he's talking about good communications, how important it is to listen and communicate effectively, and understand those governing documents. So I have a few thoughts on that. First of all, do you have websites? Okay, association web. How about newsletters? Just once in a while. It doesn't have to be a monthly extravaganza. It's important, I think, to people. And I jokingly say, and then the people who live and die by their governing documents are horrified that I say this, but I say jokingly, if you have insomnia, pull out the Declaration and start reading, and you'll go to sleep. I mean, because they are not exciting documents to read. They're essential documents, but they are not exciting. So every association has common issues, right? Whether there's pet problems, whether, it's parking issues, whether people aren't paying assessments, whatever. What I like to put out in plain language, I'm one of those lawyers that, when I'm communicating at meetings, and when I'm working with my boards on communicating to their homeowners, plain language of just reminders. It's springtime, hopefully, soon. And so we have to keep our yards clean. You have to pick up dog poop. Those kind of common things. Just reminding people, gentle reminders, not, in your face with a baseball bat reminders, but gentle reminders communicating to your community. I think boards can go one of two directions sometimes. They can either never want to enforce their governing documents because they're your neighbors and you don't want to upset anyone, or you have the condo cops over on the other side who are ridiculous, Oh, you walk too fastly through the association. Slow down. And so there's that happy medium, that reasonable medium of ensuring that you're taking actions. Boards of directors have a responsibility to enforce their documents. So one of the big things to look at is assessments. Are you dealing with assessment delinquencies? Because if you're not dealing with assessment delinquencies, you don't have the funds to operate the association. And if people get away without paying their assessments for months and sometimes years, then what happens? The rest of you have to pay for somebody who's not paying, right? So, what?
Do we? That was my question.
Well,
do we have to pay for someone that's not
what
paying?
happens
Say that non-paying person has such and such percentage of share of the assessments. Do the others have to pick up for that?
Well, what I meant was, she said, do the others have to pick up for non-paying members? If you've got enough non-paying members, basically the assessments for everybody have to go up to compensate for the money you're not bringing in. In terms of collection of assessments, Colorado law is written in such a way that if you take legal action to collect delinquencies, any attorney fees or costs that go along with that can be put on the delinquent owner's ledger and you can collect directly from them. So you get options for dealing with delinquencies. You get a judgment, a personal judgment against them. And you can garnish bank accounts and wages. You can get a receiver in there to basically rent out the unit, and use the rental income to pay off the delinquency until that's done. The big hammer that I don't use unless it's absolutely a last resort is you have an automatic statutory lien on a unit of anyone who's delinquent in their assessments. The association has the right to foreclose on that unit. That is an extreme remedy that should only be exercised as the last resort. But there's things that you can do to collect assessments. And here's the thing. I think a lot of boards, with the best of intentions, thinking, I'm really trying to do the right thing. We don't want to come off as too rough. We'll let delinquencies go and go and go because they don't want to be seen as the bad guy. And what happens is if people are in financial trouble And usually somebody who's not paying their assessments has massive outstanding credit card debt. They've got a whole bunch of stuff going on. It's much easier to collect small delinquencies than it is to collect a $5,000 delinquency. So if you let people know, look, we'll work with you if there's something that's happened in your life that makes it difficult to pay, but we're not going to let you not pay your assessments because you're going on a trip to Cabo. Okay? So, I mean, just being reasonable about it and following your collection policy, which you're required to have under Colorado law, is really essential. What other questions do we have? Yes?
Molly, one of the other visits we talked about new legislation for summer of 2015. Oh, sorry.
Okay, go ahead.
New legislation summer of 2015 requiring managers of HOAs
Yes.
to go through certain training.
Yes.
I see this other packet here is CAI, and is the CAI M100 class going to be
Okay.
accepted for the Colorado?
Yes, it's part of the M100 class is part of the CMCA. So let me explain. Beginning on July 1st of 2015, community association managers who manage HOAs in Colorado are going to have to be licensed by the Division of Real Estate. There's two fundamental components of that. The first one is you have to have a designation recognized by the state of Colorado. The CMCA credential is the basic one. And the M100 class is the prerequisite to be taken for that. Check out the Rocky Mountain chapter of CAI's website for when classes will be had in the state, but you can also do that online. There's online options for doing that. So what I recommend to managers that don't hold that credential, get your CMCA credential behind you. Take the M100 class, take the test, and get that. The other part of the licensure is there's going to be an examination on basic Colorado law. I've been talking a little bit with the Division of Real Estate on that, and that's going to be really basic is the intent. So they're not trying to get you to engage in the unauthorized practice of law. They basically just want to know that you have knowledge of statutes that you have to comply with, like open meetings, how to handle secret ballots for elections, when a board can go into executive session, those basic governance kinds of things. But the foundation right now is to get that basic CMCA credential so you don't have to worry about it. This is not an advertisement because frankly it's free. But beginning in, I think, May, check out our website. The website's on the back page. We're going to start having a monthly 1-hour conference call for managers just to start walking them through the provisions of Colorado law you're going to need to know about. So instead of sitting through a 2-day course where you're snoozing and drooling and it's not pretty, we're going to just do it in short little segments. So it's going to be a conference call. It's free. Yes?
Just to clarify what you're saying, the M100 is the basic, and then one would need to go on and get their CMCA, Managers for Associations.
Yes, the M100 course is the course offered by CAI, and I believe it's a prerequisite to taking the CMCA exam.
And then in addition to that, it's going to be some other Colorado statutes. So it's
Yeah,
a three-part.
So it's a 2-part.
Okay.
So you have the basic credential and then take a test on Colorado law.
Okay.
Okay?
What managers in an organization have to do it? Everybody who is considered a manager?
Anyone who is compensated as a manager of a homeowners association. That's the basic requirement. The statute's much more significant than that, but that's kind of the basic requirement.
You do finances and bookkeeping
That's
on the
part of the
test?
CMCA
Oh, okay.
class. Yeah. Yes.
If it's not in the declarations and it's not in the bylaws, in your own specific declarations and bylaws, can a board make individual homeowner insurance mandatory?
No. But any individual homeowner who doesn't carry insurance is nuts. Seriously. I just went through this with a client. I'm doing an amended and restated declaration of an old deck where the homeowner insurance requirement was not in the declaration. And it's a condominium association, and the condo only carries bare wall coverage. So if there's a water loss or some big catastrophic insurance event, they're going to get sheetrock and tape. And if the homeowner doesn't carry an HO6 policy, their own insurance, they're going to have to out of pocket to completely redo their unit. So no, if it's not in the declaration, you can't require it, but homeowners would be crazy not to.
And then can you amend the declaration?
To require it?
Yeah.
Yes. Yes. I'm sorry. This gentleman right here hasn't asked anything yet. Hi.
Hi, I guess I should wait here.
Cindy's getting her exercise. Do you have your pedometer on? Good.
So if your association has a management company, and that management company has responsibility for and access to quite a bit of money, what kind of security, bonding, insurance,
Okay.
et cetera, should one be requiring of one's management company?
Oh, that's a great question. So if you use a management company that is handling the finances of your association, what kind of insurance or bonding should they have? You should always have fidelity insurance. Now, the question is, does the management contract require fidelity insurance, the association to purchase it, or the management company? That's up to the parties when they're negotiating their contract to figure out who pays for it. So here's what HUD says. Here's what Fannie Mae and Freddie Mac look at. All of the income in the association, all the money held in the association, plus 2 to 3 months of reserves. That's what they suggest you have fidelity insurance for, fidelity bond. And that's really what fidelity insurance is going to cover is if somebody steals money. Okay. And you know what? If there's members of the board, a treasurer, people handling the finances of the association, you also need to be carrying that coverage. If you're a self-managed association and people are handling the money, cutting checks, you need to have fidelity coverage. Because the worst thing that can happen is if somebody steals and you don't have any insurance to cover it, it can be a nightmare. Okay? Yes.
I'm not quite sure I understand the new rules for managers having training. What exactly are the rules? How would you know whether you need to have training if you're a manager or the president of a homeowners association?
Okay, if you're the manager or president of a homeowners association for the new manager licensure, how much training do you have to have? The Colorado Division of Real Estate just published proposed rules on the regulations. If you go on our website, you can find them, or if you email me, I'll email them to you. And they're really right now looking at that, so no final decision has been made on that at all.
So I'm the president, I don't know whether I have to do this or not.
Oh, the president of the board will never have to do it. Okay? So if you're just serving on a board, you do not need to be licensed. The only time you would have to be licensed, and I don't recommend this, is if you serve on the board and you're also managing your community. And you're getting compensated for that. I don't recommend that. Is it illegal? No. But is it a conflict? Yes. But if you're doing that, you would be a community association manager who would have to get the license and go through the required training. So they're right now just looking at what that training will have to be. I would think, where are we? We're April. I would think by maybe July those rules will be finalized, maybe even toward more the end of the summer. So we'll know specifically. Yes?
So if you have no compensation, this does not.
Right. So if you are not a manager, if you are quote unquote managing but you're not being paid for it, no. I do not believe, but check the statute. Ask the Division of Real Estate, but in my opinion, no, you would not need to be licensed. Yes?
Can a board and management company legally enforce a speed limit if it's outside of law enforcement jurisdiction?
Yep.
We have residents stealing the slow signs, and it's a big problem.
Really? Are they putting them in their unit, like hanging them on the wall, or?
They steal them and they've disappeared. It's been an issue for a long time. One resident was taken to court over it already, but it's outside of the law enforcement jurisdiction.
So the question is, can an association enforce speed limits? And the question is, or the answer is, if the streets in your association are private and part of the association, and you have speed limit rules, yes, you can enforce. Where you get into some kind of gray area is sometimes the city or the municipality, the county, will own streets that go through the association. And you can only enforce on those streets is if the county or city gives you the authority to do so. But if it's private streets, yes. I mean, the problem is it's really hard. So when you're going to enforce speed limits, do you have, you know, a gun that you're measuring speed? Do you have one of those cool things that are really expensive that say you're going 36 miles an hour? I mean, the question is when you're enforcing, that's why I always have trouble with speeds, is how do you know how fast they're going? Really, I'm serious. I mean, when you're enforcing, you have to be able to have some data to show. I mean, we all know somebody's tearing through an HOA. Some of my clients have ended up, if you've got real problems, putting in speed bumps, you know, so they're not bottoming out their cars as they're going through, you know, as an option.
There's actually an app that takes the speed limit, the date and time, so I've gotten...
Oh, that's cool.
Photograph people, the license plate and speed, but the court says they can't do anything because it's a law enforcement issue. Law enforcement says it's not their jurisdiction. Right.
If they're private streets in the association, law enforcement's not going to come in and enforce speed because it's not within their jurisdiction. It can be within the association. So look at your documents, look at your plat. Are you a condo or a planned community? Okay, look at your plat map and see if those streets are private or if they are a city or county street. Then I'm assuming we have law enforcement in the back. We're not going to come in and enforce them. They're private speed. So. Actually, there's a potential of a bill next year where, and this would only be if law enforcement said, yeah, we'll do it, and entered into a relationship with an association that would give law enforcement the ability to enforce speed on private streets if the association and law enforcement entered into a contract for law enforcement to do that. It'll probably be introduced next year. Okay, it's just under conversation. Yes.
So I understand that a certain percentage of an HOA's budget has to be in a reserve account for improvements that might have to happen. Is there a realistic percentage that should be in reserve accounts minus what is required of us by state?
Okay, great question. So the question is, you know, what percentage of funds should associations be contributing to the reserve fund? All right, so every association in Colorado is required to have a reserve study policy, okay? And it basically says, have you had a reserve study done, and how are you planning to fund reserves? There's 3 ways to fund reserves. One is through regular assessments where you take some of the income from your regular dues and you contribute to reserves. Another is a special assessment, which is always popular. And then the third one is getting a loan to cover the costs of the major repair or replacement. And the fourth, really there's 4, is any combination of those items. My preference is contribute from reserves or from regular assessments if you can. You know, there's no statutory requirement that you have to reserve at any level currently in Colorado. This is going to be high, so it's okay. You know, so HUD, for FHA certification purposes, says if you're going to get certified as a condominium association for FHA purposes, says you have to contribute a minimum of 10% of reserves, of your budget to reserves every year. I will tell you from personal experience, I think that's woefully under-reserved. I want my clients to have 50, 60, 70% funded in reserves. Because otherwise, what you gonna do, right? I mean, you only have 10%. Let's say you have a $100,000 project. You have $10,000. Where are you gonna get the 90? So it's really up to you. My partner, Mark Payne, at the firm wants his clients 70 to 80% reserved. I think that's a really good number. I just don't think for many associations that's at all realistic if they haven't been reserving regularly. Marcia?
Yeah, I have a question. When you have an association that has some of the members do some of the work, you know, like upkeep work kind of a thing, what do you recommend the association do for insurance for those people? Would their regular condominium association insurance cover them when they were doing work on their, you know, in their own association?
Okay, so if members of the association are doing work, what kind of insurance should you have? Workers' comp.
Okay, so
you need to have workers' compensation insurance in place. Your general liability insurance may not cover it.
But even if they're not being paid for the work they're doing?
Then maybe your general liability will cover it. I've got to tell you, so my husband and I lived in D.C., in a Virginia suburb of D.C. before we got a life and moved to Colorado. And we were in a self-managed HOA, a 45-unit townhome association. I worked for Community Associations Institute, the national office at the time. Self-managed association except for financial management. And one day I came home on a Saturday, and there's my husband and all the board members walking down to the circle with a chainsaw. And I'm like, what are you doing? If somebody gets hurt, there's probably no coverage. I worry about this is the lawyer in me, the paranoid lawyer in me coming out. I'm just saying. I don't want members of association or volunteers walking around with chainsaws or something they could get hurt. I'm serious. I mean, it saves you money, but if somebody got hurt and your liability insurance doesn't cover it, you've got major problems. So think that through. It's a tough issue. But on the other hand, we always had the community cleanup days where that was actually great. We were all out with brooms on the asphalt cleaning all the salt from the winter or whatever. So that works. Any other questions? Yes.
Because it's usually so difficult to amend declarations or add to declarations, you need such a large percentage of approval. Can a board just add items to rules and regulations or bylaws?
Okay.
Or does that have to be in the how you change that?
Okay. So the question is, because it can be difficult to amend a declaration, can you use rules and regulations to deal with that? It depends. Let's take marijuana for an issue. So in Colorado, we have a constitutional right to smoke marijuana in our units, right? I don't think you can use a rule or regulation to prohibit smoking of marijuana in units. You could amend the declaration to prohibit it because everybody gets to vote on it, okay, and then you're contractually obligated to do that. So it's hard for me to answer that question because it really depends on the issue. If it's a use restriction that so restricts the ability of somebody to use or sell or convey their unit, I think it needs to be in a declaration, okay, in the use restrictions in the declaration. If it's general use, like I was talking about, where how we're using the common elements, what we can and cannot do on the common elements, that can always be in rules and regulations. If what you're doing in your unit negatively affects another unit owner or the common elements, can probably be in rules and regulations. So it just depends. If you really need to amend your declaration, I just say just do it. And we've got in ASPEN a whole lot of really old documents. There's some that just need to be modernized and updated. So, you know, it's worth taking a look at, but budget for it and try to build consensus in your community. Okay? Yes?
If an association amends its declarations, they need to file it. They need to register it with clerk.
Yep. Yes, so let's say you go through the process, you get 67% of the owners to consent to amending your declaration. It does not become effective, the amendment, until it's recorded with the clerk and recorder of ASPEN or Pitkin County. So if you're in this county, whatever county your HOA is in, the amendment has to be recorded before it becomes effective. Okay, thank you, you guys.